Hello, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about tubing string. Cases that should have gone to the Supreme Court of Canada, but didn't. Packers Plus filed for a series of patents in relation to a technology in the oil and gas industry that was used to deliver fluid to various types of holes. This technology that it used had previously been used in a certain type of hole, but not in others, and they claimed to have developed a method that allowed it to be used in the second type of hole and filed for a patent on that basis. Their patents were challenged and overturned on the basis of obviousness. Essentially, a design cannot be patented if the design itself would have been so obvious that anybody could have come up with it. Packers Plus argued that they had come up with this design in a way that nobody else had ever used it before, and that even though it was obvious after the fact that this was something that could be done, it wasn't obvious to anybody at the time they came up with the design, and so therefore it was deserving of patent protection. The court disagreed. And this case raises important issues about what constitutes obviousness in patents. Just because something is obvious to one person doesn't mean necessarily that it's going to be obvious to the public at large. And when the term obvious is used in patent litigation, what does that term even mean? How specialized do you have to be for something to be obvious? I'd never heard of tubing string before reading this case, and yet now I'm hearing that this would have been obvious when I'm sure that if I were looking at it, I would have no idea that this could be used in various types of holes or even the purpose of it to begin with. So where is obvious and where is the line for that drawn? The Supreme Court of Canada could have provided further clarification to this issue, whether obvious was obvious within a particular specialization, obvious to the public at large, or somewhere along that spectrum. Unfortunately, they declined to hear the case, and we're going to have to leave the issue of what necessarily constitutes obviousness for another day in patent litigation. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.